at a construction site in Bryan, Texas. A foreman, fell to his death while performing work. OSHA conducted an inspection and issued citations. The employer contested those citations, and an administrative law judge, upon hearing arguments from both sides, vacated OSHA's citations. We're going to learn why those citations were vacated on this, the February 19th, 2025 episode of the OSHA 3030. Well, hello, everyone. I'm Manesh, Rath, and welcome to the OSHA 3030. I'm an attorney here at the law firm Keller and Heckman in Washington, D.C., and for 30 years I've been engaged in representing strictly management side, and I focus my practice in the field of occupational safety and health law, amongst other areas. And I'm very fortunate today because I'm joined by my friend and my colleague, Ben Idzik, who is another OSHA attorney here at Keller and Heckman, also engages in various aspects, assisting our clients in environmental law, transportation law, as well as some employment laws. Ben, thank you for joining the OSHA 3030 today.
Thanks for having me, Manesh. It's great to be here.
Well, it's great to have you here. And I think we got a really important topic. I'm sure you would agree. Ben, why don't we share for our members of the OSHA 3030 community what we're going to talk about today?
Right. Thanks, Manesh. So like we discussed, we're going to talk about a case called Secretary of Labor versus Avidec, Inc. We're going to discuss the facts of the case. We're going to talk about the citation that was issued. We're going to get into a little bit of the background on how to establish an OSHA citation. Then we're going to discuss OSHA's arguments, Avidec's arguments, and the ultimate decision, and leave the 3030 audience with some takeaways on what they should do based upon this decision.
This is pre-recorded for February 19th, 2025. So we won't have a section after what employers should do that's off the record for just the live audience. But by all means, if any of our friends here on the OSHA 3030 community have questions, email them in to the link that you got on your invitation. And as soon as we have a off the record program, we'll have those questions queued up and ready to go. So with that said, Ben, why don't we get into this? I think we should first start with talking about the facts in the Avidec case, because I think that this is an important case when talking specifically in the construction field, but also in general industry, where regards an employer's duty to make sure they have a safety plan, make sure they train to it, and conduct internal inspections. So Avidec Incorporated. So this starts in Bryant, Texas, where a general contractor had engaged Avidec to install a canopy on the sports complex, the Midtown Sports Complex in Bryan, Texas.
All right, then after the initial phase of construction came a quality control phase. And it was during this phase where an Avidec manager and a foreman met on site to discuss some improvements that can be made after the initial construction.
Standard process after the first initial build. The manager and the foreman are now talking, meeting at the beginning of a day, and the manager approved the foreman's request to use an aerial lift to perform the work. Both of them conducted a walk-around inspection of the site as part of their meeting.
Right. And then tragically, the next day, after the manager had left, the foreman was on site and was performing those improvements that they discussed. And during the process of making them, tragically fell and was killed from the fall.
Yeah, it's a terrible story. And OSHA conducted an inspection and issued a citation alleging that this could have been prevented, but for the fact that Avidec had engaged in allegedly violative practices with regards to fall protection under the fall protection standard, and as well the accident prevention requirement that is unique to the construction section 1926 of OSHA's regulations, rather than general industries section 1910. So this accident prevention requirement, which is found in the construction side, still contains elements of general expectations, even in the general industry side. And so we're going to talk about that particular citation today.
Like you mentioned, there were two citations that were issued, but the fall protection citation was ultimately settled. The real heart of the decision came for the accident prevention citation, which is under 29 CFR 120.20.
Right, 29 CFR 1926, section 120.20. at B2. What this standard says is that employers must engage in creating and maintaining a safety program. And there's really a few critical ingredients under B2 of this standard, that this safety program requires that it contain at a minimum a requirement for frequent and regular inspections, and that those inspections include inspections of the job site and hazards associated with the job site, inspection of materials, and inspection of equipment. For example, the aerial or any fall protection equipment that's being used on a job, as an example. And the other requirement that's a minimal requirement that has to be in every safety program under this section is that the employer's safety program requires that the internal inspections be conducted by a competent person designated by the employer. And this phrase, competent person, shows up in a number of OSHA standards, and it is specifically used here in this accident prevention program requirement under 120.20. Okay, so now OSHA issues a citation, and it is a citation under a specific OSHA standard, as opposed to an alleged violation of the general duty clause, which we've covered many times here on the OSHA 3030. And when OSHA alleges a violation of the general duty clause of the Act, the Occupational Safety and Health Act, there are a set number of elements that OSHA must establish in order to prevail in asserting that a violation occurred. But when OSHA issues a citation under a specific standard, then there are a different set of elements that OSHA must establish in order to show that a violation had occurred, alleged violation of that specific standard. The first that OSHA has to establish is that it has to establish that a standard applies to the cited condition, that the scope of the standard covers the activity or the condition in the alleged violation.
Right. And then the second element, which makes sense, is that the standard that is applicable was violated.
Right, that all the elements, the requirements under that standard were being complied with, or according to OSHA, that they allege that there was a non-compliance with one or more of the specific requirements within that standard. And then the third element that OSHA has to establish, Ben, as you know, is that one or more of the employees had access to the cited condition. This is to say that even if OSHA can successfully establish that the standard applied to the activity being performed, or that there was a requirement within the standard that was not being complied with, nevertheless, a violation of the standard would not occur if there was no employee exposure to the hazard.
And the final element goes to the knowledge of the employer. The employer had to have known, or with reasonable diligence could have known, of the violative condition that was cited.
Right. In other words, if OSHA could establish even the first three elements, but the employer didn't know that a violation was in place, or through the reasonable exercise of diligence couldn't have reasonably known, then OSHA would theoretically have failed to establish that a violation of that standard had occurred. So those are the four elements. We see them in every single, as a requirement for OSHA in every single alleged violation of a standard. OSHA, when asked to assert that a violation in this case had occurred, argued that Avadak had allegedly failed to conduct an inspection of the worksite on the day of the accident. And imbued in their allegation was that even if an inspection had occurred, that it was insufficient on its face, or else it would have revealed the violation.
Right. And to that point, Manesh, the OSHA really focused on the fact that there were no documentations of the inspections. And they particularly, they pointed to the fact that under the contract that Avadak had with its general contractor, it was responsible for conducting job hazard analysis, and it did not do so in this situation.
Yeah, it's an important allegation on OSHA's part. It says, look, this standard that we're citing that requires that an inspection be done by a competent person, we didn't see evidence that Avadak had conducted a job hazard analysis on a daily basis as required by the general contractor. It is one of the requirements that the general contractor had imposed on Avadak as a subcontractor. And the other thing that OSHA alleged was that this foreman, who sadly fell to his death, he was allegedly not qualified to serve as a competent person, as that term is used in the standard, because OSHA alleged if he only reported issues that he discovered to the manager and the manager had discretion as to what to do about it, then it stands to reason, OSHA argued, that he was not himself the competent person, but that the manager would have been. And that argument OSHA gave on the basis of evidence that it submitted that the foreman himself always reported issues to the manager. This is ironic, of course, because the foreman reporting issues to the manager requires as a predicate that the foreman recognized an issue as such and recognized it as reaching the level of sufficiency that it should be reportable in its degree of seriousness. And that, to me, serves as indicia that he was indeed competent to recognize hazards and understand them as reaching a reportable level of seriousness. But OSHA took that and read it the opposite direction, that if he had to report issues, then that means he wasn't the competent person, the manager was. But I don't think that the standard, by the way, requires that the internal inspections be conducted by the most competent person, provided that the inspection was conducted by a person who was indeed a competent person. It need not matter which competent person conducted the inspection. Ben, I hope I said that clearly to illustrate the problem that I see with OSHA's argument.
Yeah, certainly, definitely. And I think that when we get to Avidek's argument, they go directly at this issue and push back. One of the first points that make is that, in fact, the manager and the foreman did conduct a walk-around inspection the day prior to the aerial lift being used, and then ultimately that led to the tragic death of the foreman. As you recall, that after the conversation between the foreman and the manager, both of them took a walk-around inspection. So Avidek focused on that as being satisfactory of the standard.
Yeah, that's right, Ben. And the other thing that the judge noticed was that OSHA's allegation that the general contractor had required Avidek to do a daily job hazard analysis was not evidence of anything relevant to the cited standard, because a job hazard analysis is not the same as an inspection. That the standard requires internal inspections by a competent person, and that whatever the general contractor had required does not create a legal duty under the standard itself. First of all, job hazard analyses are different from inspections. They're an assessment of what the hazard is. An inspection is an assessment of what the conditions are, the practices are on that at the time of inspection. And second of all, that the general contractor himself, its requirements upon a subcontractor do not get converted to a requirement of law under this particular standard. I think that is an excellent point by the administrative law judge, and I hope that it is translated by administrative law judges also to manufacturers' operators' manuals, for example, that whatever the operator's manual says is not the same, does not rise to the same level as compliance with the standard or non-compliance with the standard, unless the standard itself says you have to comply with any instructions in an operator's manual. But I digress there, and I point out that this opinion relates specifically to the dichotomy or the discrepancy between a general contractor's requirements and the standards requirements. OSHA is stuck with the standards requirement that there be an internal inspection, not daily job hazard analyses.
That's exactly right, Manesh. And another issue that Avidek pushed back on was this idea that the foreman was not a competent person. They said that he was, in fact, a competent person because he was given the authority to take corrective actions on the work site to eliminate hazards.
And he had received training, and he had a number of years of experience, and he was capable of, he had demonstrated capability to perform this work competently and safely. The other thing that that Avidek argued was that when you look at the foreman's manager, the conversation that they had the day before, the foreman's manager noted that when he approved the use of aerial lifts, he noted to the foreman that you have to use tie-off, you have to use fall protection. Indeed, the foreman's response, according to the manager, was none of the other subcontractors are using tie-off when they use aerial lifts. It's not commonly done. And the manager responded, don't worry about what other subcontractors are doing. you and your team have to use tie-off, have to use proper fall protection compliance when using the aerial lift. And so the manager had spotted a hazard potential associated with the use of aerial lifts, had identified it, and had given proper instructions to the foreman on the correct use of the aerial lift, and instructed the foreman to correct the deficiency of not using tie-off or proper fall protection methodology when in an aerial lift. So that's Avidek's arguments. The administrative law judge looked at the arguments on both sides. And I think the first thing that the administrative law judge noted, as I pointed out, was that an inspection had been performed, and that the day prior it was performed both with the manager and the foreman together.
That's right, Manesh. And then, like you discussed earlier, the ALJ pointed out that the standard itself does not require documentation. Just because the general contractor required job hazard analysis does not mean that Avidek was required under OSHA's purposes to take those same documents.
That's right. And the administrative law judge noted that the written safety program that Avidek had in place was found in 3 different documents: a handbook, a safety health program, a program specifically for fall protection, and then there was a procedure for fall protection, and there was as well a safety and health program for on-site hazard analysis. And the judge noted that all of these were consistent with each other. So their written safety program, collectively taken from all of these documents, which were internally consistent with each other in requiring inspections before each assigned job and whenever conditions at a given job changed, was sufficient to comply with the requirement of the standard. And when the agency argued, well, but they didn't use proper fall protection, so that is automatically evidence that they didn't have a sufficient safety program, the judge pointed out that the citation that they were asserting was a alleged deficiency in the safety program requirement. And they did comply, indeed, with the safety program requirement. They had a capable written safety program, and they did, in fact, conduct inspections. One was conducted the day prior with both the manager and the foreman, and the foreman was clearly a competent person, as the standard would have required. And so the administrative law judge looked at all of that and looked to the specific requirements of the standard and said, we're going to go ahead and take a look at what the standard requires and not what the general contractor required or any other outside sources. And we believe that Avidek has met the requirements of the standard, that the foreman met the definition of a competent person, and that OSHA had not supplied sufficient evidence of a violation of that standard requiring a safety program that included inspections by competent persons. Accordingly, the judge vacated the citation, which I think is an incredibly important decision for employers, especially in the construction sector, but also, I think, in the general industry sector. Ben, as you know, we represent a lot of manufacturers, distributors, manufacturers in all sorts of sectors like materials manufacturing, food processing, producing, et cetera. And I think even in those sectors, this is still illustrative, because although there isn't that specific standard that's found in the construction side, there are requirements, and it's baked into the general duty clause as well, that there be a job hazard analysis, that there's internal monitoring for compliance with all of the specific standards, and that there's a program in place to create a requirement, comply with the standards, train employees, and monitor for compliance on a day-to-day basis. So I think the standard is incredibly important for the construction sector, but also for the general industry side as well. Then, with that said, why don't we talk for a moment about what we think employers should do in light of the Avidek decision?
Definitely the first and sort of a cardinal rule I think that all employers should follow by is just to maintain and constantly update written safety policies. These are important, as we see here, and they can be the make or break it versus getting a citation and not getting one.
Yeah, I think that's right. Ben, I think it's important to start off with conducting a job hazard analysis and having a written safety plan, and to maintain that safety written safety program, update it and keep it up to date, but also to incorporate any hazards associated with the task. If it's a fixed hazard, fixed site like manufacturing, for example, but if it's construction or a job site that is fluid in nature, then to perform an on-site job hazard analysis, and potentially, if not daily, then as circumstances change. But in this case, Avidec did a daily job hazard analysis, not just because it was required by the general contractor, but when multiple managers and supervisors and safety and health professionals from Avidec testified in this case, they said that the reason we do a daily job hazard analysis is because things can change. And so I think the second thing that you and I, Ben, would recommend to members of our OSHA 3030 community would be to perform a job hazard analysis. If you're in a fluid job site, to do so on a daily basis or as things change, and even at fixed sites to do them frequently, but certainly at the beginning of commencing operations.
Yeah, that's exactly right, Manesh. Also related to that is just the importance of training employees. I think one of the things that we discussed in this case was how the ALJ gave credit to Avidec for having consistent training policies at the company, which included training upon employees hire and also occasional refresher trainings. It's important, and it lends a lot of credit towards an employer in the citation contest.
Yeah, I think that's right, Ben. Not only at orientation, there should be a general training on general safety and health practices and imparting the importance of it, but as well on each specific policy. And then when there's a job hazard analysis, and in this construction site, it was on a daily basis, that has to be communicated to the employees as well. And as well when new tasks are begun. So for example, when an employee engages in activities involving fall protection for the first time, that fall protection training be conducted prior to that, operating new equipment that the employee is certified for operating cranes or derricks or other types of heavy equipment. And that kind of training is just ongoing. It's not a one and done kind of activity. I think the other thing, Ben, that you and I have talked about as in light of the Avidec case is that once you develop a safety policy and have performed a job hazard analysis and employees have been trained, it's important for employers to continue to monitor on a regular basis, daily where appropriate, and even more frequently than that where called for, to monitor workers for internal compliance with those expectations from the employer, and that those frequent and regular on-site internal inspections should not only include inspections of the job site and of the materials used and of the equipment being used to make sure that the equipment is in safe and working order, but also to make sure that employees are performing their tasks the way they were trained to and not cutting corners or have forgotten their training or just decided to dispense with them maybe when nobody's looking. So that frequent monitoring and internal inspections, I think, is a critical component that really came to light, the value of which came to light in light of the Avidec case.
And very much related to that is also ensuring that employers, when necessary, discipline employees and record those disciplinary actions, not for the sake of punitive punishment, but for the sake of educating employees on proper safety practices at the workplace.
Yeah, I think that's a great point, Ben. It's not just writing somebody up for an infraction, but there's coaching and counseling. There's a lot of times where in an on-site walkthrough, a manager might see a deficiency and may not write it up, but may tell an employee, remind an employee how to do it properly. That I would call coaching and counseling, but it fits under the general or larger umbrella of disciplinary action. I think notes should be written up in that manager's walkthrough notes so that there is a written record, not just of write-ups or infractions, but also of coaching and counseling events that have occurred during that walkthrough. That I think is a critical record that helps employers working together with their OSHA counsel to present a effective defense that the employer did everything it could. I think the next thing to take away from the Avidec case is that employers have to constantly conduct training, not just the kind that we talked about for the workforce, but also for the on-site supervisors, safety and health professionals, to make sure that they are qualified as competent persons as standards require, that they're capable of conducting on-site inspections, and that they're given the tools, checklists, et cetera, and of course the training to conduct an effective internal inspection.
And then finally, I think, as we've seen in this case, which was a major point for OSHA, is just to ensure that there are supervisors on site with the authority to take corrective action. This goes back to the battle here between whether the foreman met the definition of a competent person. I think it's an important step for employers to take to ensure that such folks are on every work site.
I think so too. Well, Ben, you have the last word on today's OSHA 3030. Thank you all for attending. A few administrative notes. We will have our next episode of the OSHA 3030 live and up March 19th, 2025 at 1 p.m. Eastern time, always on a Wednesday and always at 1 p.m. Eastern. So stay tuned in your inbox for notices for that OSHA 3030, the March 19th, 2025 OSHA 3030. And when you get that email, please remember, as we've said many times before, the only thing we ask of our friends in the OSHA 3030 community is to forward it on to at least 3 other people inside your organization, in your Office of General Counsel or your safety and health professionals, and at other organizations where you have friends who are in the Office of General Counsel or safety and health professionals responsible for compliance with occupational safety and health and for making their workplaces safer. So please forward this invitation on to them. When we grow the word about the program, we've been doing this for 12 years, and when we grow the word about the program, we assure a better chance that we can continue the program for years to come. Don't forget our sister programs. If your organization is responsible for compliance with REACH or TSCA, our REACH 3030 will be held next on April 9th at 10 a.m. Eastern. And our TSCA 3030, terrific programs run by some incredibly talented attorneys here at Keller and Heckman. The TSCA 3030 will also be on April 9th at 1 p.m. Eastern. So stay tuned for invitations in your inbox about those programs. Well, on behalf of the wonderful staff here at Keller and Heckman who helped bring this program together, and my colleague Ben Idzik and myself, Manesh, Rath, here at Keller and Heckman, we're thankful to all of you for participating in this month's OSHA 3030. We look forward to seeing you again next month. And until then, stay safe.